Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. This is the second presentation which purpose is to consider the concept of control in the EU sanctions law. And it follows on our original presentation where we already considered control. And the reason for this continued discussion is that if there is one subject which causes most of time, most of uncertainty, and most of dedication and interest from the operators, then it appears that this is the concept of control. And accordingly, we will try to expand on the original presentation which we made on the subject by briefly touching again on the sources of interpretation of control. So what is the legal basis to understand what control means? We will then look a little bit deeper into the historical origins of control in the EU sanctions law and generally consider whether it's inevitable that a sanctions regime shall operate with the concept of control. What are the broad purposes for retaining this concept? Then we would discuss how an operator can establish with certainty the presence of control or the absence of control against certain facts, whether the relevant aid shall be the EU Council or Commission, the EU courts, national courts or national competent authorities, or whether ultimately the operator shall rely just on itself and take the relevant measures which would be sufficient to dissociate itself from the blocked persons. And we would offer some concluded remarks at the end of this presentation. Certainly, the starting point in establishing control for the purpose of application of the blocking sanctions, but not always, sometimes control is also relevant in the sectoral sanctions context, would be the legislative acts where the control is defined. It's defined actually only by reference to a company controlled by a blocked person in the terrorist regulation of the European Union. The second basis for establishing control scope in the legal sense would be the judgments of the European courts, which are the only authorized bodies to interpret European law as a general separation of powers in the European Union. Then would go the opinions and guidances of the European Commission. Each of these documents will be preceded by a statement that only the European courts are authorized to interpret law. But nevertheless, this is no more than the general statement as to the separation of powers, the Commission being the executive branch and the courts being the judiciary, and as a result of this separation, the executive branch not being authorized to interpret its own acts as a matter of law. Having said this formal assessment does not in any way detract from the value which the operators and the member states can gain from reviewing the opinions and the guidances of the European Commissions, and not only because of the practical considerations, as the European Commission is actually proposing the relevant sanctions laws and actively participating in the drafting. So certainly it has the first-hand view of both the political objectives which are behind these legislative norms, as well as the exact form in which the relevant provisions were framed, but also because the European Court of Justice acknowledged the role of these opinions and guidances as being necessary and useful to clarify the general scheme and the general purposes of the legislator and the executive branch, and by doing so, the opinions having substantial importance both in the litigations in the European courts and in the national courts. I mentioned here two opinions which are specifically dealing with the equivalent of control in the European sanctions law, as well as two guidance programs with respect to sanctions in Syria and Russia and Belarus. Finally, EU best practices are of the same value as the opinions and guidances. These are the summaries of common understanding of the member states as to what the meaning the relevant tense should have. Similar relationship with the judgments of the European courts. Nevertheless, if one would carefully review all the relevant normative acts, case law, and doctrine which is relevant for the interpretation of control, the summary is inevitably that control is the ability to influence the decisions, and this ability does not require the presence and is not dependent on the presence of any formal right, whether based on the contract, law, tort, or any kind of other formal relationship. And this is the main complexity with the application of control. The factual ability to affect the decisions is sufficient to establish control, and accordingly, for the operator to come to a conclusion that control or is not present, it needs to know all relevant facts, which in most of the cases, the operator can learn from publicly available information or from a person which is controlled and with which the operator has either a contractual dispute or some sort of other relationship. Publicly available information is hardly to be adequate, and in any case, in practical terms, would often be very strongly criticized by the relevant party, which an operator may allege is controlled on the basis of such information. It's not a reliable source, and certainly not a source which can bring to any type of agreement as to the correctness of legal treatment. And as far as the information which comes directly from the relevant suspect, let's put it in this way, is concerned, then again, it could hardly be reliable and, of course, will present the picture in the way which is most favorable to the relevant person. So what is clear is that criteria is hardly certain, depends on a very extensive due diligence of the facts, and given the inherent limitations which most of the private operators have to face in terms of the sources where these facts can be found, is unlikely to result in any kind of definite conclusion. It's a good time to pause at this moment and to have a thought, why to have this concept at all? At the end of the day, we talk about an area of law which is trying to achieve an overriding political objective, namely putting international pressure on a foreign country. This objective is pursued by quite substantial limitations on the human rights of the relevant persons which are affiliated in one form or another or otherwise connected with the relevant country. Most often, in the case of ownership and control, this will relate to the asset freeze of such persons of indefinite duration. And certainly, against the background of these important political objectives and very severe limitations on important rights, one would expect clear, understandable rules which are easy to follow in practice. On top of these, sanctions laws require that the breach is punishable, among others, by criminal penalties, which are established in the member states, as well as in some jurisdictions, the liability is established on a strict liability basis. This adds further important arguments towards importance to have legal certainty in those rules which carry with them this type of penalties and this type of liability regime. So what may be the explanation for the importance of control? First point, one might think that the reason why control is often there is that because it's just an inherent part and parcel of any sanctions program. It's just how the things are, it's just how the programs are drafted. And accordingly, one would hardly think of anything operationally feasible without the concept of control. Well, actually, that's not the case. By far, the most efficient and the comprehensive national sanctions program, the program of the United States, as a general matter, is not operating with the concept of control. Well, it's present in some of the sanctions regimes, for example, Iran. As a general matter, the US sanctions program is based on the point of listing the relevant persons by name, and as far as it's impractical to reach out to all persons by way of listing, to use the concept of ownership, which certainly adds substantial legal certainty as to what is the reach of the relevant sanctions regulations. So we can see that the common perception that control is just there and it's impossible to operate without control and efficient national sanctions regime is not proven by looking at probably the most efficient sanctions regime. Next two explanations, which are commonly cited together, is that control is important to avoid circumvention, because otherwise it's quite easy to find a structure where no formal ownership elements are present, but nevertheless the blocked person still, by careful corporate engineering, is able to enjoy the economic benefits of the relevant assets, as well as to encourage the operators to take substance over form approach in their sanctions compliance and focus more not on the formal legal analysis of whether any type of ownership interest is present, but more on a substantive analysis if there is any element of de facto ability to influence the operations of the relevant companies. And by doing so, the sanctions regime is more efficient because it ensures the better attitude of the operators, as well as prevents the circumvention of the relevant restrictions. Well, again, it's quite easy to test the validity of this argument by reference to the United States. And one does not need to follow the sanctions enforcement action on a daily basis to have a view that sanctions enforcement in the United States, given the, for example, number of settlements publicly available on the website of OFAC, between OFAC and almost every major bank in the world, is by far more efficient in terms of A, detecting circumvention of the US sanctions programs, as well as encouraging operators to comply with the sanctions programs. I think the compliance with the US sanctions program is probably by a distance a more efficient compliance, not just within the territory of the United States, but also in the third-party jurisdictions. It is also worth noting here that certainly a prohibition to engage in any activity which is aimed at avoiding the legal effect of the sanctions restrictions, i.e. circumvention, is an offense in itself, and it is not clear what exactly control adds to this general prohibition. Reason number 4, the historical legacy of the EU sanctions regime, seems to be a more plausible explanation of why the EU sanctions regime focuses so much on control. And indeed, if we think historically, the first sanctions regime in the EU were the replica of the UN regimes implemented at the EU level. And the wording which is used currently in the EU sanctions regimes is basically the mirror replica of the relevant wording of the UN sanctions regimes, which indeed operate with the concepts of ownership and control. And indeed, the regulations which establish currently both the UN sanctions programs and the autonomous sanctions programs basically use exactly the same language. This is a good explanation of the origin of the concept. It's not a good explanation as to the reasons why this concept is continuously used, at least with respect to national sanctions programs, which in their scope and effect go far beyond a standard UN sanctions regime. They're much more far-reaching. They affect a larger pool of companies and number of people. A standard UN sanctions program would make subject to asset freeze somewhere in between 20 and 30 persons. All of them will be subject to the decision-making of either the UN Security Council itself and the veto rights of permanent 5 member states, or the committee set up by the UN Security Council, where the same member states will have their representatives with the same type of rights. So there is clearly a very different decision-making process, which results in substantially fewer people being subject to those restrictions, and those persons typically would be directly involved in the military hostilities in the relevant region, which the UN Security Council purports to address in its resolutions. This is not the case anymore in national sanction programs, which go far beyond both in substance and in numbers than the UN sanction programs. Final point explaining the importance of control in the UN sanctions law may be the decision-making process in the European Union and the US. In the US, the decisions are made by, in essence, a single agency within Treasury, OFAC, and this single decision-making authority is actually able to adjust efficiently to the changing circumstances, so to list persons if deemed necessary to exert pressure, as well as to delist them given the change of circumstances, change of political agenda, or any other circumstances. Which makes operating on the basis of the listing criteria, presumably, and ownership criteria as a subsidiary basis for the introduction of the US sanctions easier. In the European Union, the decision-making process requires consensus of all member states. There is no delegation to some type of executive agency. And presumably this means the control can serve as a more flexible tool which allows each member state to adjust the exact scope of sanctions application within its territory. Even if this is the case, this doesn't seem to be a good explanation given the overall purpose to ensure the common market and uniformity of sanctions laws within the European Union, which is the first reason why these matters are dealt at the EU level rather than at the level of member states in the first place. So all in all, it's important to see from here that despite the complexity of the application of the concept and almost impossibility for the operators to decide on their own whether control is or is not present. There is no very clear either historical or political or practical purpose behind the concept of control. So one might imagine then that in this situation, there would be a efficient practical mechanism which would allow the operators, while complying with their due diligence obligations, have recourse to some authority which would then help them to decide if control is or is not present in the particular case, and by doing so would align their day-to-day tasks with the overall political objectives which the sanctions law purport to achieve. We would now look whether indeed the operators have this kind of assistance. Let's first consider the EU legislator in the sanctions laws matters being the Council, in the first place, and Commission in the secondary place as a body which proposes legislation, and the Commission itself as the executive branch and the enforcer of the laws. Would they be of any help for our operator in the difficult task of establishing whether control is present in a specific case? With respect to the Council, when listing persons, the Council would typically describe this listing by reference to the matters and facts which justify the listing, and while describing those matters and facts, the Council would periodically mention various companies where that person may have substantial shareholding, or which may be associated with the person, or where even this person, in the judgment of the Council, may have control. And then, presumably, despite this assessment, the Council will not list these controlled entities in their own name, leaving it to member states to decide how they would like to deal with the matter within their own jurisdictions. These statements of the Council, unfortunately, are of limited help to the operators, because the purpose of the statements is not actually to establish legally that the relevant entity is controlled or asset is controlled by a blocked person, but it's more to describe why the blocked person is blocked in the first place. So, whilst a helpful starting point in any analysis, unfortunately, these assessments are of no legal value and cannot be of substantial help. The European Commission took the view that it's not its job to make the assessment of control in individual circumstances, and accordingly it appears that the executive branch of the European Union is also not in a position to assist the operator in the circumstances when it's uncertain whether certain facts may lead to the establishment of control or not. Now we look at the judiciary, which is, at the end of the day, the only branch authorized to interpret European laws, and by doing so, may be of potential assistance. Unfortunately, also the role of the judiciary in the practical day-to-day establishment of control is of limited scope, because the European courts do not issue declaratory judgments on abstract matters unrelated to a specific dispute. And this specific dispute can also come to the European courts in just two ways. The first is the judicial review proceedings, which require the direct effect of the relevant blocking statute on a person, unlikely to be found in the situation of control when the relevant control entity is not listed by name in the relevant regulation, or preliminary review proceedings, which are initiated by national courts and within which the national courts can refer to the European Court of Justice for its interpretive guidance, whether a certain fact pattern results in the presence of control within the meaning of the EU sanctions laws. So first of all, it appears that the venues where the relevant matters may be escalated to the level of the EU courts are very limited. The second of all, dependent on the discretion of the national courts to exercise the procedures, and they are certainly dependent on such procedures being started in national courts, so a certain dispute coming in front of national court in the first place, being a judicial review matter against a decision of the national competent authority or a contractual dispute involving the issue of control. And then the national court shall escalate this for the review of the European Court of Justice, whether the relevant proceedings take on average 2 to 3 years. This certainly is a lifeline for day-to-day business operations and difficult to be of practical use in the various issues which many operators may face on a daily basis when immediate decisions or quasi-immediate decisions need to be taken as to the presence or absence of control. Same refers to the national courts, whilst in the national courts, the procedures for some sort of declaratory judgments may be more flexible. Given that the matter relates to the interpretation of the European law, it is not unthinkable that the national courts, when faced with this type of issue, will refer the issue to the European courts. And by doing so, again, we're faced with the same type of limitations we've just discussed. So it seems that as far as the national courts, as the potential venues where the matter of control cannot be established are concerned, these will be and are indeed largely engaged in the context of commercial disputes between the relevant European operators and their counterparties, which they deem to be controlled by both persons, with all the relevant risks for the European operators, meaning that if potentially their judgment is not believed to be accurately taken or based not on a full consideration of the facts, these operators can face potential negative consequences as a result of such disputes. So ultimately, as this is the only venue for the operators, it's important to take advantage of the relevant exculpatory provisions, which in essence shields them, at least to the extent the national claims are brought in the European courts, against liability which may arise in connection with a good faith, although potentially wrongful, application of sanctions. It's a limited comfort, I would say, especially given that the disputes may not be brought only in the European courts, but can be brought also in the arbitration tribunals or in the courts of other jurisdictions. And that at the end of the day, there is always a possibility that the courts would not deem the operator to be diligent enough to take advantage of the exculpatory provisions. Next, recourse for an operator which wants to establish control without testing his position in the course of the civil litigation is the national competent authorities of the member states. And indeed, one might think that in the original structure for the operation of the concept of control, at least in the view of the European Commission, the key role was allocated actually to the national competent authorities, which within their jurisdictions should be able to assess the facts related to specific companies or specific assets and state whether the control is present or not for the operator to take a cost and time efficient decision with respect to the matter, which on the one hand shields such operator from the potential criminal liability that it acted imprudently with respect to the relevant assessment, and also civil liability that it acted overcautiously and just for the purpose of, taking unnecessary restrictions with respect to the relevant company. Unfortunately, it seems that the legal framework is not really consistent with its practical application. Almost no national competent authorities publish their findings of control, at least not in the European Union. The only exception here can be OFAC, which makes some determinations in the complex circumstances. So they publicly say whether they believe that a particular company is, in their case, owned by a relevant blocked individual. But certainly, as OFAC operates with the concept of ownership and not control, the practical utility of this type of determinations within the European Union is very limited. Certain national competent authorities make determinations, but on a private basis, meaning in respect of the individual request on the operator, the national competent authorities will respond to this operator saying that, in their view, this type of relationships results or does not result in control. And by doing so, will certainly assist this specific operator. But nevertheless, this creates uneven field because the other operators might very well not be aware of this type of decisions and may come to the opposite conclusions, and then would face potential criminal liability from the national competent authorities. Finally, some national competent authorities do not issue even this type of individual judgments, assessments, but deal with the matter just as a formal application process, which is certainly very much restricted as to the grounds on which the application can be submitted. So the situation which operators can file is that the application is rejected on other unrelated to control basis, and ultimately they start with square one when they need to determine on their own whether control is or is not present and whether the assets should or should not be blocked in the first place. Often when justifying this type of approach, the national competent authorities refer to the exclusive roles of the courts in the determination of and interpretation of the laws, and they need to consider each case on a case-by-case basis, which is certainly correct as a formal matter of law, but is again hardly useful in the day-to-day life of the operators. So at this moment, having tried all these venues, the operator may resort to self-help remedies and try to establish the firewalls, especially taking that the European Commission agreed that these may be an efficient mechanism to separate ownership and control between the blocked persons and the relevant companies in the European Union. There are two options which are proposed for establishing valid firewalls: state law provisions adopted at the level of member states, whereby specific legal regulations are adopted and explain how firewalls operate with respect to a different company, as well as self-constructed firewalls, whereby the relevant company itself tries to modify its corporate structure in a way that would convince first the independent auditor, and second the national competent authority, that the blocked persons do not have any type of ownership or control relationship vis-a-vis the company and its assets, and would certify, both of them, that there is no ownership and control as far as those national competent authorities are concerned. It seems unlikely that this method will substantially advance the matters. First of all, because in essence it adds nothing new to what already was the practice, because to the extent the national competent authorities really wanted to interfere into the management of a specific company, for example, which was owned and or controlled by a designated person, they already interfered using their national powers, either in the context of restructuring and insolvency laws, or in the context of the right of the state to nationalize the relevant assets, and then issue the relevant statements to the public that, in their judgment, the relevant company is not owned or controlled by the relevant designated person. So in this sense, the mechanism has always been there and has been used for quite a period of time. And it's not clear what exactly is added by the relevant guidance on this matter. More importantly, it seems that there are very substantial limitations to this mechanism as proposed by the Commission. There is no cross-border recognition. It appears that it only works for the EU or potentially Swiss entities not outside of the European Union or those countries which align with the European Union. Their sanctions programs, which makes it hardly unlikely to be workable for large global integrated groups. So it seems that although certainly a welcome step in terms of giving the relevant companies a formal option of how they can demonstrate to their counterparties, their employees, their clients, that they're not controlled by a blocked person, it pretty much reflects the already existing status quo and the difficulties which it presents for this type of situations. So where it ends us at the end of the day? One logical view on the matter would be that there is a overriding necessity to have legal certainty in the application of sanctions. Due to very substantial penalties they may result in, but not only, also from the perspective of their efficient implementation, that the resources of the operators are not wasted for second guessing and third guessing the points where they cannot come to a definite conclusion in the first place, but employing them on compliance with the matters which clear certain and ultimately ensure to a more efficient sanctions program. And it seems that the United States, which again have probably the most extensive, the most developed, and in terms of penalties, the most efficient in terms of enforcement sanctions program, is doing this without control as a general matter. It seems unlikely that this change would occur in the European Union in any foreseeable future, given the decision-making process which we've just discussed and the ultimate absence of flexibility of how these lists can be operated. It would require a substantial overhaul of the whole structure of the sanctions law and the reallocation of the enforcement matters to the level of the European Union agencies rather than national member states. With this in mind, it seems that control is to be here for any foreseeable future, and the factual focus of the matter, as we've discussed, makes it difficult to ensure, even for the very diligent operators, that they do not incur either liability towards the regulator or liability towards their counterparties while reaching the decisions. So the operators need certainty, and the certainty, it seems, should come from the executive, because the factual analysis of the matters is very specific. It requires time and cost-efficient decisions, and most importantly, it's highly politically sensitive, because at the end of the day, sanctions laws achieve a political objective, and in this sense, it's for the executive branch to make its view clear to the regulator as to how they should behave against the factual circumstances of the regulator. This appears not to be the case so far, and for the regulator and for the operators, the only viable route in the current circumstances seems to be the civil litigation and reliance on exculpatory provisions in terms of any claim for damages which they may face if ultimately their assessment as to the control is not supported by the courts. So for the operators, the key emphasis in the current environment seems to be on due diligence to ensure that their actions cannot be classified as being done not in good faith. Final thought is that if control is to be present and in the interest of public certainty, there is a need for a publicly accessible list of the entities which are deemed to be controlled by the national competent authorities, which is available to all European regulators, practitioners, and their legal counsel. There can be no secret about this type of assessments and decisions. They're in the interest of everyone. They're in the interest of justice, enforcement of law, and fair treatment of the relevant operators and their counterparts. I trust that you found this presentation useful, and thank you again for watching.